or a fresh charge sheet, it is only a report which is additional to the report that has already been filed. That is how, my lord, the language of section 173, 8 says. My lord, well, have a look at section 173 subclause 8. It can't be a fresh charge sheet or a supplementary charge sheet. It is a report which is filed in addition to the report that is already filed.
What do you say the report?
My lord, yes, I shall come
The
to that.
charge sheet filed under 173(2) is also termed as a final report.
Quite right.
The same way, this is also a report.
Yes, my lord, that is exactly what I'm saying. No, have a look at 173 subclause 8, my lord, for a
Yes.
second.
Yes.
Although my lord would be coming across the day in and day
Yes.
out. Just for my satisfaction, let me invite
Yes,
my
sir,
lord's
yes, yes.
kind attention. Let me not be
Yes.
mistaken, my lord. Nothing in this section shall be deemed to preclude further investigation. Yes, my lord.
Yes.
In respect of an offence, after a report under subsection 2 has been forwarded to the magistrate, and whereupon such investigation, the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to the magistrate a further report or reports regarding such evidence in the form. That means it will be a further report to the report that has already been filed. No quarrel about that.
Yes,
issue.
sir.
And, a further report has been filed. Presumably, my lord, basing on the additional evidence which the investigator would have collected, my lord, the trial court would proceed to alter or add the charges to the charges that has already been framed. But after altering or adding the charges, what is the procedure that needs to be followed?
216.
216. But that 216 is subject to 217. Have a look at section 217 first.
216 at any time, even after the judgment is reserved.
Quite right. Quite.
Yes.
Now that is subject to
Yes.
217. Have a look at section 217. My lord gets it.
Yes.
Whenever a charge is altered or added to by the court after the commencement of the trial, the prosecutor and the accused shall be allowed to recall or resummon and examine with reference to such alteration or addition any witness who have been examined, and thus the court has reasons to be doing it. But this is the procedure which is required to follow. Instead, what he does is he would order for a de novo trial. That is impermissible under law.
Subsection 4 of section 216.
Yes, but that is exactly I submitted to your lordship.
Yes.
This is
Either direct a new trial or adjourn the trial for such period as may be necessary.
But have a look at the first two sentences.
Yes.
If the alteration or addition is such
Yes.
that proceeding immediately with the trial is likely, trial has already been over, trial has come to an end. It is a case where the trial is yet to commence. Well, 216 subclause 4 comes into play, or it could be pressed into service, provided the trial has not commenced. Here in the instant case, trial has already commenced. That means recording of evidence is almost over. 65 witnesses have been examined. No, my lord, charges came to be altered or added. Then, my lord, the procedure which the trial court is required to follow is under section 217, not under section 216(4).
Recall of witnesses.
Yes, my lord. Instead, what the learned judge says is, he will go back to chapter 18. Have a look at chapter 18.
Yes.
Well, what he does is, well, chapter 18, no sooner the final report is filed, and at 226, the prosecution is required to state its case.
Yes.
227, the accused can make his submissions for an order of discharge. 228, the court can proceed to frame the charge. Thereafter, 229, 230 evidence, recording of evidence. That means, again, reopening of the case for a fresh trial. It can't be done. That is the law. That is what the learned judge has done here.
Let's see. Now, where is the order, sir?
It warrants certainly consideration at your lordship's hand because a serious and important legal issue has been raised.
No.
May I just request your lordship to kindly turn
Where
to...
is the impugned order?
Yes. Well, I shall take your lordship to the operative portion of the order, which my lord gets at page 142, ink page 142. But he can't fall back upon 216(4). 216(4) comes into play only before the commencement of the trial. Otherwise, only 217. Kindly read. Application filed by the accused number 12600 section 231 CRPC thereby disposed of by directing the prosecution to conduct the trial as enumerated in section 216(4) CRPC. Needless to mention that the materials, etc., etc. Then, my lord, liberty to examine the witnesses as contemplated under section 230 and 231. What is not permitted, he permits. 230 and 231 comes into chapter 18, commencement of trial, not otherwise.
What was the application filed?
But we would say, continue. Well, let him examine the additional witnesses that is filed in the supplementary charge sheet as fresh witnesses. I have no objection. But if he wants to examine the witnesses who are already examined during the trial, the provision that could be pressed into service is only on 217. Recall them. Do it. I have no objection. But now the procedure that is being followed is, again, my lord, he is PW1, he is PW2, he is PW3. That is impermissible. That is the first submission which I am making on the legal issue.
Yes.
Well, the second submission is, my lord, although, my lord, we every now and then we say that the prosecution is the master of itself as far as the examination of witnesses are concerned. But it should not be detrimental to the interests of the accused, and it should be a fair trial. But he will file a list of witnesses on the first occasion, which I have produced. He would seek for issuance of summons. The court would issue summons. But for one reason or other, the matter is adjourned. Again, he will file an additional list, second list of witnesses for issuance of process. Process is issued. Witnesses are present before the court. One among them came to be examined in part. Then, my lord, the matter is adjourned at the instance of the prosecution. Next time, he would file another list of witnesses.
Repeating those very.
No, some other persons. Well, that is what the Supreme Court has condemned. May I just invite my lord's kind attention to the judgment of the Supreme Court.
So according to you, 217 permits recall of the witnesses and not bringing in new witnesses. In a case where it is under 216(4).
Yes.
Yes.
Tuxi, subject to what my lord would ultimately say.
Yes.
216(4) is only in relation to a case where the trial has not commenced.
That we'll see.
Here, the trial has commenced.
No, 216 deals with alteration of charge. Now, alteration of charge, commencement of commencement of trial or conclusion of trial has nothing to do with alteration of charge. It can be altered at any time.
Anytime it could
At
be.
any time.
As my
The
lord has
procedure after that is under 216(4) and 217 is what we'll consider it. Yes.
What has- In fact, in the prayer which came to be made by the prosecution, they would ask for de novo trial. May I request your lordship to kindly turn to paragraph 17, 16 and 17. Well, this is a full bench judgment of the Supreme Court, criminal trial guidelines. Kindly go to paragraph 16 and 17. The counsel appearing for the states and the High Court submitted that the provision in the draft rules requiring the trial should be concluded on a day-to-day manner cannot be complied with. It was argued that the courts have to more often than not postpone or adjourn cases due to non-availability of witnesses or on account of absence of defense counsel or the prosecutor. The learned amicus curiae submitted that given that the trial begins after charges have been framed, the prosecution witnesses should be available on the dates of trial for the simple reason that they are relied on for proving the charges. It was submitted that this court should indicate that as far as practicable, the trial court should carry out beforehand sequencing of witnesses, deposition in terms of eyewitnesses and other material witnesses, formal witnesses, expert witnesses, etc., and also factor in some specific date of dates so that effective depositions are recorded on every date of hearing so fixed. Well, para 17 would be important. This court is of the opinion, well, the previous paragraph is the submission which came to be made
this
by
is
the amicus. This court is of the opinion that the courts in all the criminal trials should, at the beginning of the trial, that is, after summoning of the accused and framing of charges, hold a preliminary case management hearing. This hearing may take place immediately after the framing of charges. In this hearing, the court should consider the total number of witnesses, classify them as eyewitnesses, material witnesses, formal witnesses who would be asked to produce some documents, etc., experts, At this stage, the court should consider whether the parties are in a position to admit any document, including a report of experts or any document that may be produced by the accused or relied on by her or him. If so, the exercise of admission/denial may be carried out under section 294 CRPC, for which a specific date may be fixed. The schedule of recording of witnesses should then be fixed by giving consecutive dates. Each date so fixed should be scheduled for specific number of witnesses. However, the witnesses concerned may be bound down, etc., etc. But here he files a list of witnesses. First day, second day, some other witnesses, third day, some other witnesses, and he does not even summon or secure the presence of a witness who has been examined in part.
No, now we'll have to answer. What is the purport of the word new trial in subsection 4 of section 2 and 6? If that is taken note of, then whether witnesses can be brought in afresh. That is what is.
That your lordship has got to ultimately.
ಅದಕ್ಕೆ ಯಾವುದಿಲ್ವಾ?
ಅದಕ್ಕೂ ಇದೆ ಬೇಕಾದ್ರೆ virtually
Alteration of charge, I'm aware that
ಅಲ್ಲ,
it can be done at any
but
time.
question is virtually does it not tantamount to a de novo trial, which is impermissible under law?
That-
A fresh trial means
Wait.
a de novo trial.
Get back.
Well, there
ಬೇರೆ
are
ಯಾವ್ದು judgment ಇದೆ?
any number of judgments.
216 I'm aware, sir. What
260.
alteration of